When a person passes away, his assets need to be taken care of and divided among his relatives and friends. In many member states, notaries play a crucial role in this process. The rules applicable to the allocation of assets are, however, not identical in all member states. In some member states, individuals enjoy a large freedom to decide on the fate of their estate. In other member states, family members are protected and are entitled to a given share of the estate. And in yet other member states, family members may agree beforehand on the division of assets, while this is prohibited or only allowed under strict conditions in other member states. In order to deal with cross-border questions relating to successions, notaries must answer a number of questions. They must find out which law applies to the succession, for example, in order to determine whether the deceased could provide in his will that some of his assets would go to a friend, or to determine what are the rights of the surviving spouse. Notaries are also required to determine how to deal with an authentic act which was drafted by a notary in another member state. And in some cases, it will be necessary to find out whether the local courts have jurisdiction to hear a dispute related to the succession. In 2012, the EU adopted an important regulation dealing with all these questions. The succession regulation came into force in August 2015. It provides pan-European answers to the main questions arising in relation to cross-border successions. The regulation does not attempt to harmonize the law of succession. Member states remain free to decide how they shape their laws of succession. However, member states are bound by identical rules on the cross-border aspects of succession. With the regulation, notaries can in the first place identify which court has jurisdiction to hear a dispute concerning a cross-border succession. The regulation also provides conflict of laws rules. The first principle under the regulation is that anybody can choose to have his succession governed by the law of his nationality. This possibility to choose the law governing one's succession may prove very useful for expats, but also for anybody who wants certainty on the law applicable to his succession. In the absence of a choice of law, the regulation provides that its succession is governed by the law of the last habitual residence of the deceased. This means that one should identify in which country the deceased spent the last years and the last month of his life. In some circumstances, it may not be easy to identify the habitual residence of a person, in particular if that person moved frequently from one place to another or divided his life between several countries. The regulation attempts to make it easier to deal with cross-border successions, and it does so by ensuring that the applicable law will coincide with the court having jurisdiction. This is done by tying jurisdiction and applicable law to the habitual residence of the deceased. The regulation also provides a very useful instrument for the family members of the deceased. If they need to rely on their right as heir or legatee in another member state, they may request that a European certificate of succession be delivered. This certificate, which must be issued using a uniform template, provides indications on the position of the heirs and legatees and also of their rights. It is delivered by notaries or courts after a thorough verification of the circumstances of the case. This certificate is a powerful document which opens many doors for the family members and the legatees of the deceased. It helps them asserting their rights vis-à-vis banks, debtors, and other third parties. The succession regulation is a very important legislation. Every notary in the EU should be familiar with its key rules to be able to apply them for the benefits of its clients.